Awesome. Well, good morning, everybody. Thank you for joining us for Canadian Policy 101, How a Policy Becomes a Law. Really excited about this, as I'm sure I will learn a lot too. I want to thank you for joining us. I'm going to keep your videos and your mics off so that we can hear the wisdom from Anna. And I'm just going to introduce her briefly, but I'm sure you all know her probably. But Anna Linter is or Anastasia, I call her Anna, but is a daughter, sister, auntie, mom, and recovering academic, which I absolutely love that. Dr. Linter is also a passionate public interest environmental advocate. She is Special Projects Counsel, Healthy Great Lakes for Canadian Environmental Law Association, Principal of Linter Law and Adjunct Professor, Geological Sciences and Geological Engineering at Queen's University. The highlight of her legal career thus far was the opportunity to combine economic and legal arguments for the Supreme Court of Canada in two cases, one involving the valuation of sensitive environmental lands and the other involving the intersection of insolvency protection and environmental cleanup obligations. Dr. Linter specializes in environmental assessment, conservation and water law, and Ontario's Environmental Bill of Rights. So thank you so much for agreeing to do this webinar. I'm going to turn it over to you.
Thanks, Christy. As I get started, I just want to make a huge shout out to Nancy, who's knowledge mobilization specialist at University of Waterloo's Water Institute. She and I developed the workshop Science and Art of Freshwater Policymaking for an in-person student-led conference in Kingston in 2014. This is the first time that I'm delivering the materials online, and particularly Nancy saved the day because I couldn't find the graphic that I wanted to use that I hand drew for this workshop back in 2014, and she found it. So it wouldn't be this webinar this way without Nancy, so thank you so much. What we're going to seek to do today is provide an improved understanding of the process of freshwater policymaking, our roles in shaping freshwater policy, and where you can get more tools. It's a processy driven explanation. That's the science. This is how it works. These are the steps. And it's also an art because it's about relationship building and choosing a pathway. And I'll reveal that more as we go along. This graphic, a picture of a particular replica of the dish with one spoon wampum. This one, a cherished copy that I have of the wampum, is crafted by Ken Markle of Cayuga Nation. And this particular law, an agreement, a treaty between the Haudenosaunee and the Anishinaabe, is an important agreement within the Great Lakes Basin where I live. What I've learned about this law is that it was offered by the Haudenosaunee to the Anishinaabe. It is primarily white, meaning it is an offering of peace, and it is a dish in the center. The white in the middle of that is a representation of the beaver tail. It's a dish with one spoon, seeking to share the lands, to share the bounty of the basin, because there is only one bowl, there's only one dish, there's only one ecosystem, and we need to all respect it and take care of it so it will be resilient and help sustain us and future generations. It's one of the many laws that make up the Indigenous legal system, sometimes called Indigenous legal traditions, here in the country we now call Canada. And I acknowledge that I am still learning, and I expect, like many of you, on my own path of sorting out an understanding, a learning, and a sharing of the knowledge, and changing the ways in which I do my work. What we're going to talk about today is the settler system, the Canadian legal system, and policymaking as one of the opportunities and tools that we can use, and there are many more. We don't have a lot of time together today, so I'm just going to be narrowing in on Canadian policymaking. And although I'm a lawyer, what I'm telling you today is not legal advice, legal information for your use. This slide deck is available on CELA's website if you want to download it. And as well, as Christy mentioned, we are recording so that we can make the recording available afterward. I'm going to be talking about all of the potential processes for getting involved in public policy. There are many pathways, and I encourage you to get involved, if you're not already involved in policymaking, in at least one way. And I want you to not be overwhelmed and feel that you have to get involved in all ways. So as I reveal this diagram, don't be overwhelmed that somehow you have to know it all and get involved in all of it. So here it is, the overview of the systems and processes of public policy in Canada. I'm going to break this down a bit today. And as I said, these slides are available. Also, if you send me an email after this webinar, I will send you a handout, an electronic document that has this graphic on one side, and on the other side we'll have a description of jurisdiction that explains division of powers, which is another thing I'm going to talk about. So public policy, as you probably all are aware, is more than just laws. It's funding priorities, it's the plans and programs that are delivered, it's the regulatory measures, and we're going to focus a fair amount on laws today and the sources of settler law in the legal system within Canada. There is the common law doctrines that everywhere in Canada except in Quebec, the common law doctrines can be superseded by legislation that's made by our elected officials and made by Parliament federally. And that legislation is superseded or overseen by the rule of law, so no one is above the law, and the Constitution, which has both protections for the Charter of Rights and Freedoms and protections for Aboriginal and treaty rights. The public policy cycle, if we start with thinking about agenda setting, this can be revealed through party platforms. When we are having elections, they can be revealed through mandate letters and what's called speech from the throne at the start of a parliament or a session of the legislature, the priorities that are being set, and civil society, citizens can speak to elected officials, speak to civil servants, and talk about what's important to them and what they think the solutions are as a way to talk about what ought to be the priorities for government. Policies are formulated, decisions are made and implemented and evaluated, and then will that policy be renewed, improved, or terminated? And that cycle goes around and around, and we have opportunities to get involved at lots of points. Most often folks think about getting involved at the agenda setting, but as many of us know, continuing to have a well-implemented policy or a well-implemented law is also crucially important. One of the things that's important in determining how you want to have an issue solved or a new policy put into place is to understand who's responsible. And in Canada, that is a matter of jurisdiction and the division of powers. So back in 1867, when Canada was established in terms of the British North American Act, the federation of the federal and provincial governments, there was a list of division of powers, sometimes called heads of power, that were allocated to the federal government and to the provincial governments of the time. And this is a list of some of them. So federally, the authority given by the Constitution in matters of seacoasts and fisheries and navigation and criminal law, and what's called the residual clause, the peace, order, and good government, for things that didn't get captured and are of national importance or national concern. Here I've used the term Indian because it is the term that's used in the Constitution Act 1867. And in Canada, very complicated, very interesting. If we had another day to talk about all of these things, I would want to talk to you quite a bit deeply about this term, Indian, how it's been interpreted, how it's different than Inuit and Métis, and the evolution of the colonies laws, colonization and laws, and inherent Indigenous continuing legal systems and laws, but we can't do it all today. So just telling you why it's there like that. Federally, powers are delegated to our 3 territories. So territories do not have constitutional powers. They act through their delegated authority from the federal government. And then provincially, jurisdiction over local matters, civil rights, non-renewable resources and forests, public lands. Those are provincial heads of power. And municipalities or local government do not hold constitutional power. They have their authority delegated to them by the provincial government. So neither territories nor local governments or municipalities have constitutional powers. They're exercising their powers that have been delegated to them by the federal or provincial government. What you might notice is nowhere in this list is the word water. And so what we know from case law is that water is very much a shared jurisdiction, and there are hints about how the oversight of water is split between federal powers like fisheries and navigation and seacoasts and provincial powers around matters of a local nature, property that's within the province. And so we know that, for example, with the Great Lakes, from the coasts of the large lakes like Lake Ontario, and I live just at the end of Lake Ontario as it turns into the St. Lawrence, Lake Ontario, the coast and out into the lake, because it's an international shared water, is federal jurisdiction. And then, you know, from those Great Lakes coasts up into the province to the headwaters, that is internal waters, inland waters, and it is provincial jurisdiction. And so we have the Great Lakes Water Quality Agreement between our federal government and the US government. In order to implement it, there needs to be an agreement between the federal government and the provincial government, and we have the Canada-Ontario Agreement that's in the process of being renegotiated and needs to be renegotiated about how that shared jurisdiction is going to be taken care of. And in terms of terminology, we have Parliament, often a term that we use to talk about combining the elected officials and federally the appointed senators, along with our representation of the monarch in Canada, which federally is the Governor General. That's when we talk about Parliament, and in terms of being able to make a law, you need Parliament. And There's an analogy of what happens at the provincial levels. There are lieutenant governors in each of the provinces that are the monarch's representative. We don't have an appointed Senate at the provincial level, and we have legislatures or houses of assembly in each province or territory where the elected officials make laws. At the federal level, the Senate is referred to as the upper chamber, as I said, appointed by the Prime Minister. The House of Commons, these are the elected officials or members of Parliament. It's referred to as the lower chamber. And then we have three branches of government: the executive, the legislative, and the judicial. The executive is the combination of the Prime Minister and the appointed ministers of the different departments, the cabinet ministers. And together, the Prime Minister and his or her cabinet are called the Governor in Council. The monarch is the Governor General. Together, they're the executive branch. At the legislative branch, the Senate and the House of Commons, and as I mentioned before, there is only the elected officials, representatives of the elected officials at the provincial level. And then completely independent of that is the judiciary, with oversight over what government does. So it's possible to challenge government decisions through this independent judiciary. So you have a sense of all of the systems that are involved in policymaking. And so there are lots of pathways for somebody to get involved in shaping it or influencing it or expressing concerns about what ought to be taken into account or enacted. There, as I said earlier, there are lots of ways to get involved, to influence, to engage, and you don't have to do all of them. And I strongly encourage you, if you're not already, to do at least one of them, to become involved, pick your pathway, because we are public policy. We need to express what's important to us and why our elected officials ought to take notice and do something. So we can influence, for example, spending priorities or funding priorities in the budgetary process. Federally, we have a collaborative called the Green Budget Coalition, which meets annually and follows the federal funding cycle to talk about what are the priorities from the environmental sector for each year's determination of what will be the budget priorities. You can engage locally at your municipal level with municipal resolutions, with influencing bylaws, and again, sort of appearing and speaking to your elected officials municipally about what's important and how to solve the problem that you're seeing. You can go to court with litigation, challenge, as I said, government decision-making because it's unconstitutional or because it's exceeding the jurisdiction of what it's been delegated to do. That's called judicial review. And we can seek to influence legislation. And in influencing legislation, some of you are probably thinking, oh, isn't that lobbying, or oh, isn't that political activity? That's a whole other really interesting description of what is lobbying, what is political activity, how are they same or different, and how much can you do for another day. And reach out to me if you want to know more about that. So picking your pathway, that's more of the art about what is going to be the path to achieving what it is that you want to see done to address a particular freshwater issue. So if we're looking at the legislative process itself, it starts with an idea, remember agenda setting, that's developed into a bill, which is introduced to the House or the Senate, depending on where it originates. It's debated. It's sent to committee. which deliberates and often has public hearings or an opportunity to have a say in what you think of the bill. And then from committee, it comes back to the chamber and it's voted on again. At the federal level, we have the two chambers, the House and the Senate. So once the bill goes through one of the chambers, it needs to move to the other one. Bills can originate in either the Senate or the House. And if you happen to be looking at the bills that are being debated right now or have been introduced, if they have a C at the start, they've started in the House. If they have an S at the beginning, they started in the Senate. The bill must be passed through this process. The bill must be identical in terms of what the House and the Senate agreed to before it can continue on to become a law. So sometimes the bill will get introduced, say, in the House, and it goes to the Senate, and the Senate wants to make some changes. Then it will need to come back to the House, and the House will need to approve them or change them again before it comes to the point where both houses, both chambers have passed the same bill, and then it can go to the Governor General for royal assent and get signed into law. Within the bill itself, there's going to be some provisions about when it comes into force. It'll either say that this bill comes into force on royal assent, so it's automatically a law, and sometimes it'll say that it will come into force on when it's proclaimed. And proclaimed is just another process by which the executive is going to give an order about the point in time at which it will come into force. So sometimes laws have been passed and received royal assent, but they actually aren't binding yet because they haven't been proclaimed. And that's the law making, the legislation making process. There's only one time through if we're at the provincial level because we don't have the two chambers. And there's lots of other processes. There's the budgetary process. We do not have an analogous situation of appropriation as there is in the United States. We have this budgetary process. Budgets are tabled in our legislatures and they're debated. And if there is a budget when it's introduced is automatically what's called a confidence vote. So if a government's budget is voted down, that will defeat the government and bring about an election in Canada. So the budgets are important, particularly in minority parliaments. There's regulation making processes. There's the opportunities through litigation, court and tribunal processes. And then in Ontario, we have the Environmental Bill of Rights, which guarantees residents in Ontario the opportunity to give feedback on proposed acts, regulations, policies, and what's called instruments, which are authorizations or permits or licenses that are listed as requiring public participation under the Environmental Bill of Rights. All of this happens through the Environmental Registry, and there's a need to do those, seek that public input before the decision is made in most cases. So I've given you, I think, a sense of how there's lots of pathways. You can kind of talk about the steps in an objective way, the science of the processes, but it's also an art in terms of thinking through what is my issue, and then what jurisdiction are we talking about? Do we have to persuade the provincial government or a municipal government, or sort of who's going to be the decision makers that need to understand the importance of the issue and what the solutions are. And it's about a number of things. So to give you a sense of an example from experience is the Great Lakes Protection Act. In terms of agenda setting, there's a group in Ontario, the Ontario Priorities Groups, which releases annually public policy priorities on a website called greenprosperity.ca. For a number of years, Green Prosperity called on the provincial government to set out in legislation the importance of the Great Lakes, all of the waters of the Great Lakes within the ecosystem, set out how important they are and what are the plans to ensure that they're healthy going forward. And after a few years of this being a priority that was put forward, we saw an announcement in the throne speech, or the speech from the throne, which opens Parliament or legislature and sets out the government's priorities, that there would be legislation on the Great Lakes. And so a number of groups got together and set out expectations of what was important from the environmental sector that would go into a bill about protecting the Great Lakes. The expectations document was taken to all parties. We work, all of us, in nonpartisan way. So we briefed all parties who were interested in hearing our thoughts on that. A bill was introduced and debated, and we had it die on the order paper, which just means that there was an election. So all of the bills no longer exist and have to be reintroduced. It was reintroduced the third time it was reintroduced. When it went through the process, even though it had been through the process almost all the way to becoming a law, the second time through, it had to be reintroduced and it had to go through the process all over again. And it was important, and I think it's important that when the government is doing something that you agree with and you think is important, it's just as important to stand up and say in a standing committee, for example, that this is the right way to go. We agree with it, and please make sure it gets passed, as it would be to appear before a standing committee, for example, and say this legislation needs to be improved in the following ways. And so we put in some effort to make sure that we reassured the members, which are all parties represented at the standing committee, that it was important and it ought to be passed and brought into law. And then once it was, in 2015, it is enabling legislation. So you need to continue to work to have it implemented. So if you're thinking of that public policy cycle, it's because it's enabling legislation, it's only going to do the things it says it proposes to do and the purposes if it's actually a priority of government to continue to use those tools to protect and restore the health of the Great Lakes ecosystem. So implementation efforts become important as well. As I mentioned, this deck is available, so you can download it and have access to just this tiny number of resources that are about the federal legislation, how you make a law, and how you can see all of the bills that are currently available and all of the past bills on Legisinfo, and a larger document about how things move from policy to proclamation, which is becoming a law. And as I said, send me an email and we will send you back a two-pager that will have the systems and processes diagram, as well as a summary of division of powers, so that you can be thinking about the kind of who's responsible question. And now I turn it over to you all to see if you have any questions.
So everybody's on mute. If you want to unmute yourself and ask a question, please go ahead and do so. Thanks.
Hi, Anna. It's Andrew.
Hey, Andrew.
I'm just wondering, we in Canada often have issues with the implementation phase, that the legislation goes through, but then we have trouble in terms of who's in charge and what the budget is and how it's going to get done. And that might be analogous to a term that you referred to earlier, which is the American familiarity with the appropriations. Could you maybe talk a little bit about implementation in Canada and enlighten me and our American colleagues as to whether or not that's a good analogy?
Right, so the system here is very different. So while, as I understand it, if as rulemaking happens in the US, you also have to show the appropriation. And in Canada, it's slightly more nuanced. You can't introduce bills without knowing that they will be supported by budgets, but you are not sort of doing the things in complete tandem. So that's why I sort of described that the legislation making process is actually separate from the budget cycle or the budget making process. And the kinds of things that you might be bringing to the attention of government, at least in my experience, I can see this very directly at the federal level in the way we work through the Green Budget Coalition, which is all about the numbers. What's the important program that's going to meet the goal of an environmental solving an environmental problem, and how much money is it going to cost, and will you allocate that in your budget, versus going to, say, at the federal level when there were intentions of improving the Fisheries Act and how it worked. Then it was about the legislation and how do we really protect fisheries. Let's get in, let's have a purpose statement, and let's ensure that the protections and the prohibitions will lead to protection. So they really are, although they overlap quite a bit, I see them as separate opportunities to influence. You're going to need different kinds of information and persuasive arguments for each of them. And one of the things I think we could do better is to think through those two things at the same time, even though they're not required of us to present all at once or to influence all at once. Be thinking about them as both being important. And our experience just after the Great Lakes Protection Act was passed to ensure that it can, that its implementation became a priority, and the challenges that we've had there are a matter of kind of demonstrating how it's not enough just to get the bill passed.
Thank you so much.
Hi, Anna, it's Nancy. Thanks so much for a great refresher on this. It was really good. I'm wondering if you can talk a little bit more about enabling legislation and what I guess the opposite of enabling legislation would be sort of the rules and standards and enforcement type of legislation. I don't know if there's a term for that. And if we're headed towards, maybe you agree with this or not, but using more enabling legislation in our law setting, how does that change our approach to advocacy if we're looking for water protection?
Mm-hmm. So thank you, Nancy. So enabling legislation permits the government to take certain actions. So in the example of the Great Lakes Protection Act, the Act talks about the purposes, and then it has a bunch of mechanisms that can be used, but don't have to be used. And so one of the things that makes legislation more effective in terms of binding a government into action is if if there is within it mandated requirements. And so one of the things about enabling versus, you know, requiring or binding commitments within a legislation is whether or not it's may, which is permissive, and the government has the choice, discretion about whether or not they do it based on all their competing priorities, versus shall, which is a mandate that they must do it. So that's one piece of the sort of enabling versus, I don't even know if we have we probably do have a very simple word for the other type. It's not coming to me right now. And then the other way is, are there schemes already within it, the piece of legislation, that allows somebody to ensure that it happens or it's enforceable? And so even if there is a shall in a piece of legislation, there may not be a mechanism to enforce that shall. So there may not be a way in which somebody could hold the government to account by saying, this says shall, and then there's a power to enforce that. And then the last little thing I'll say is that there are a number of environmental laws that are very clearly about, here's, you know, say the Ontario Water Resources Act. Here's the purpose of the act, the wise use and management of our resources, our water resources, and then a prohibition that says you shall not pollute, and then a way in which you can get permission to pollute through licensing, and then an enforcement mechanism, so that if you violate the prohibition or if you don't meet the conditions of your permit, then there is an offense, and the offense can be enforced. And the offense in Ontario can be enforced both through government prosecution, but also through private prosecution. So that's sort of the landscape of the ways in which laws can be just kind of offering that the government has these powers and then they have discretion to use them, versus tighter or more binding laws. And the more discretionary they are, or the more enabling they are, then the more that's going to be required to make sure it sustains as a priority and is given the resources, and the government has set through their mandate letters to their ministers that this is the way, this is the tool they're going to use to achieve the goals, versus another option of policies or programs. So that's why it's important to say that those are priorities and that they remain priorities, and this is the way that it could be seen to achieve them.
Great, thank you.
So, Anna, this is Christy. I'm just curious. I think I heard you right when you said if a budget doesn't pass and it's voted down, it signals an election. Is that correct?
Right. So
That's
we have
really interesting.
Yeah. So in Canada, in our elected legislatures, the House of Commons and the legislatures or legislative assemblies, the government forms by the party that has the majority of seats, but you may not have enough of a majority to pass your bills if the opposition decided that they didn't agree with them. And so sometimes in minority, they call it minority parliament, if there's an issue that the minority government introduces something, the opposition can always call for a confidence vote. And so what I'm saying is that budgets are always confidence votes, and they really matter more when the governing party doesn't hold the majority of the seats and therefore can put through the bill without everybody else agreeing. So yeah, what that means is that our system can go along on uncertain cycles depending on how the House is formed at the election time. There's no fixed cycle.
Thank you. Are there other questions for folks? Or for Anna, I'm sorry.
Well, people are thinking about another question. Just for the last question from Christy, there's no horse trading at committee on Canadian budgets. The American system of discussing and amending a budget is far more open. And here, even an amendment to a budget, like a small item to add $12 for a children's new playground, if that amendment to the budget goes through, the budget is deemed to be defeated. And then there has to be a motion of confidence in the overall budget. So we have far less collaboration in a meaningful budget for multiple sectors. It's basically what the government wants.
And I'll just add to that a little bit that what we've noticed is also more recently that the budget bills contain a lot of amendments across a lot of different administrative functions, and we call them omnibus budget bills, and they certainly in our assessment don't always contain entirely administrative sort of budgetary amendments to other pieces of legislation, and it's very challenging in Andrew's example where you think, you know, this one of, you know, pages and pages and pages of amendments to a lot of different pieces of legislation. This one isn't really about budgeting, but more about you know, changing the way in which a law to protect the environment is going to be operating, trying to get attention on that one thing in amongst all these other things and have it changed, just given the reality of how, you know, standing committee works and how the hours get delegated and how many people they listen to and how many issues there are going to be across an omnibus bill. It's becoming increasingly challenging to make those changes or to persuade a committee to make those changes.
Thank you to both of you.
Anna, it's Nancy again. I don't mean to dominate, but if no one else has questions, I'm wondering if you can talk a little bit more about how people might engage in the process. So I think what you've done, especially with the story around the Great Lakes Protection Act, is explain well how the environmental sector was involved in helping ensure that that act was eventually passed and also implemented. How are other sectors involved, or maybe the better question is, how might you see the whole system functioning better if more sectors were involved or more of the public was involved in the process?
So one of the things that gets discussed more and more and more around taking an ecosystem approach and looking at, you know, a watershed, and if we were just thinking about water, what are the means to ensure our water is clean and safe, our, our natural systems are restored, instead of just stop degrading them, actually restore them, and the opportunity for a resilience in terms of creating a better functioning watershed that would do a whole lot of things, right? Allow us to maybe have better protection for drinking water sources, less flooding, like lots of different ways in which the solution, sort of starting with the solution of creating a watershed that acts more like a natural watershed instead of a, paved, disrupted, hardened shorelines watershed. The things that we could do and see a healthy watershed operating or acting have so many potential interests, if we can call them that, involved, that I imagine that if we had those voices from all of those interests saying this is the solution to, enhancing our integrated watershed management or whatever the solution is, and these are the 4 priorities we can do to do that, the more voices that are saying that across different sectors, if you want to call them, not just the environmental sector, but others who have an interest, who take an interest, who think it's important that we do it this way, the broader, more diverse that collaboration with those different voices, I think the more likely it is that we're able to solve the problem and have governments see that that's the solution and move it forward. And so there's definitely been examples where folks partnering with industry and saying, hey, government, this is a solution, and then government taking the step to make it so. And I don't know if that answers your question, but that's where my mind went when you asked the question.
Yeah, I think it makes sense. I mean, what I'm trying to do these days is work to engage students and professors and people part of academia to participate in the process. And one of the challenges is a lack of understanding of what that process is. So I hope that I can share this webinar with them. But I also think it's just, I think sometimes people don't understand what their role is or what they could contribute, or that their voices do matter. So some of it has to do with that too.
Right. Oh, I have so many experiences. I still dabble at Queen's, as Christy said. I'm a recovering academic, so I'm not a full-time academic, but I still like to teach. And when I tell students that they have a right through the Environmental Bill of Rights to comment and have your comments considered and have the government tell you how your comments were considered, the sort of like, well, nobody cares what I think. And that I hope we can reframe that attitude to I have an idea and I should feel comfortable expressing it. And sometimes the government's going to be obligated, like they are through the EBR, to take that into consideration and demonstrate how they've considered it. And sometimes it will be a different path. Like I really loved the conversation with Chad last week, and it's sort of like our elected officials are people, they're researchers, and their staff are people, and they want to help solve these problems. And if you build relationships and you help folks solve problems, help them understand why it matters, help them think it through, even offer the solutions, which sometimes is the legislative wording, it's gonna make it easier. And Nancy and I, because we've been trying to do this since 2014 generally, to help people understand that we are all public policy. We elect our officials, and our taxpayer money goes to these programs. So, and you don't have to understand the whole system or be expert or be a policy person to get involved. And getting people over that threshold is going to continue to be a challenge. And I saw that Paul raised his hand.
Yeah, hi Anna. So this is more of a, I guess, a general public policy question than a water one. But and it links back to what you and Andrew were talking about, and kind of what you said was, you know, somewhat sort of disturbing or concerning move to omnibus bills. It made me think of a larger question about, you know, the natural tendency for whether you're a bureaucrat or an elected official is to push the envelope. So whether it's on, you know, budgetary process, policy process, what kind is there an ombudsman process, or is there a parliamentary officer just kind of overlooking, you know, where people are starting to get to crossing the line on the rules, or is that simply a matter for the voters the next time they go to the polls?
So what came to mind was that we have auditor generals federally and provincially, and in our auditor general offices, both federally and provincially in Ontario, we have environmental commissioners. And so there are mechanisms to ask that you review a way that environmental law is being implemented or interpreted. You can ask questions through, it's very clear, petition process federally. You can seek to ask the questions in a less effective way from when we had an independent Environmental Commissioner of Ontario. The office is now within the Auditor General's office, but it's still there. And so there are, you know, somewhat independent mechanisms within both federal and provincial government to have that oversight. And so there are audits, and there are audits that you can go back and look at in terms of some of the environmental sectors, and then the government's reacting to those and improving systems. So there are some schemes and opportunities within a particular government, and then obviously the ultimate power is in who we elect.
Hi. It's Gail.
Yeah, go ahead.
Thank you. Can you talk a bit about what the powers are of the Environmental Commissioner now that that office has been shut down and it's been relocated? What is the status?
That's a great question. I didn't review the powers directly before, so I'm kind of going from memory. But my understanding is that the powers related to sort of the powers about reporting on the annual implementation of the Environmental Bill of Rights are not identical to what they were before, but are similar. And one of the very concerning things that changed was when we had the independent office. If you wanted to exercise one of the rights under the EBR, which is the right to request a review of a piece of legislation or a policy or a regulation, sort of how these things are being implemented, how they could be improved, you ask for a review, an application for a review. They used to go to this independent office who would send them on to the ministries, and then you had that reporting mechanism through the independent office, and that doesn't exist anymore. The requests go directly to the ministers. And so that sort of oversight role has been removed. Although that said, as I said, there's the discretionary powers within the current commissioner's role within the Auditor General to still review what's going on. And we saw that comes out annually with the Auditor General's report. If there is an independent, not an independent, but there is a chapter about environmental auditing. So that's what I can recall off the top of my head. If you want, you can always email me, and I can just quickly add additional information about how things had changed.
Thank you so much.
So we're coming up to the top of the hour. We may have, if there's a an answer or a question with a short answer, but otherwise, Anna has put her contact information here. I really want to thank Anna for walking through this, and Nancy for finding those slides for Anna. This was really great. Appreciate your time and parting with your knowledge. And if other people have, things that they want to learn more about in terms of Canadian policy and stuff like that, happy to set that up with you know, Anna or others, and just reach out to me. Really appreciate everybody's time. I did get a question in the chat saying I thought this meeting started at 11. I'm not sure if there was a breakdown in the calendar or something, but no, it started at 10. But it is being recorded, so we will send it out to everybody so you have that as well. So thank you so much, Anna. Really appreciate it. And have a really great day, everybody. Please stay healthy.